So I am new to the AI world and Forbes and so forth. And I'm not new to the concept of AI. I actually grew up, my mother was a computer programmer back in the 80s, and she worked for Milton Bradley. And one of her first jobs was to convert Connect 4, which is a physical, you drop checkers in, to a one-person game on a TI 99/4, which was a cutting-edge machine back in the day. So I spent a summer with her playing old-fashioned Connect 4. We had numbers on all 42 checkers. There's 42 spots here. There are more than 4 trillion combinations of red and black. If you do all the math, there's actually more if you count the empty spaces. And so we would drop them, we numbered, we played. She'd take a Polaroid picture and she'd try to figure out patterns because there was not enough compute in the 80s to do this from scratch. So she was trying to figure out, but I've been doing that, been around AI for a long time. I'm going to talk about 3 things that in the law that are basically changing or under assault or otherwise radically different because of AI, big data, and technology generally. One is privacy. We've all heard about it. We all know there's hundreds or thousands of laws out there, HIPAA, library, taking books out of a library, all sorts of other things. But we haven't really got to the essence of privacy. We haven't got to what it feels. And I use this example because of it. So in 2014, U2, which was certainly one of the biggest bands in the world, not the at the time, did a deal with Apple. And they did their own branded iPod, they had their own branded, et cetera. But what they also did is they released an album called Songs of Innocence. And the day of the release, they actually had it automatically download, sent to every single iPod, iPhone, and iTunes rights holder. So when they woke up in the morning, they had the entire album. Great, right? I have a free album from U2, whatever. It was a disaster. PR disaster for Apple, PR disaster for U2 and the band. Why? Because people felt their phones, their music choices are personal and it's private, and you shouldn't be able to put your album into something I don't want. So as a result, Apple scrambled the rest of the week. They had to put out a patch to be able to take it off, not only to hide the songs, but also literally undownload them from the various devices that existed. And it really struck Bono. In his memoir, he has this line that he said stuck with him after all these years. He said, you know, some anonymous, I don't know if it was Twitter or somewhere online, said, you know, the free U2 album that I got this morning wasn't worth the money that I didn't pay for it. So that's privacy. Second thing, copyright. Copyright is under assault, okay? Copyright gives a creator, author, musician, artist, whatever, an exclusive monopoly over their work for a period of time. Their lifetime plus a period of years. It's gone, the number of years changes over time, but essentially the idea has been around since the 1720s, more or less. LLMs are trained on basically copyrighted works, for the most part. There is some government stuff that's free, there's some stuff that's fallen out of copyright, et cetera, but they're essentially have been trained on it, and it's under what's called a fair use. However, if you are the author of Game of Thrones, Fire and Ice, George R.R. Martin, your entire world, your characters, everything you have is basically being, or at least in the allegation, in his allegation is a suit. He's suing most of the LLM manufacturers along with John Grisham and another of prominent authors. But it's degrading economics from me towards the LLM. That is a problem as far as what are the incentives to create going forward. Taylor Swift has had one way of dealing with it, right? She goes on tour. So she's had trouble with her copyright. She actually had to re-record 6 of her albums about 5 or 6 years ago. The Red, the 1989 Taylor's version. That wasn't because she wanted a new version, because she lost control of her copyright on the original version, so she re-recorded them. The money she made now is all on touring, and that's why you see all these big bands out touring, because copyright, Napster and the various other, before the streamers, so before the Spotifys of the world, basically there's no more album sales. So the way people make money now is on tour. Final thing, liability, which is really about accuracy and hallucinations. 2 examples here. Netflix, for those of you that, you know, are maybe not as young as you'd like to be, Netflix started out as a DVD company. And so you got a DVD in the mail, you watch a film, you send it back, and then a week later you get your next DVD. They spent millions right around the 2010, 2011 period, trying to figure out what you might like next. Building an algorithm, what comes next, if you like this movie, you might like this movie. At the same time, it was effective. People liked it, they checked it, et cetera. They then moved from DVD physical things to streaming. When they went back to the algorithm failed. So the subscribers were the same, the movie library they were building from was essentially the same, yet people no longer liked, or the algorithm no longer predicted what people were going to like, which shows you a small change in a tweak in an algorithm has a potentially huge impact. Last thing, I don't expect you to know who this is. He's a law professor. His name is Jonathan Turley. 2 years ago, there was a query put out. Somebody did a query about sexual harassment among law professors. And his name came up with a bunch of facts associated with it, where he taught law school, the date of the event, and a Washington Post article that didn't exist, but nonetheless was in the response to the query. Somebody called him up, and he said, well, it's the wrong law school. That date, I was actually out of the country, not where this alleged incident occurred, and the Washington Post article didn't exist. So he wrote an op-ed about it, saying, look out, hallucinations happen, I'm a victim of one. And, a month later, the Washington Post itself, which was involved tangentially in the article, ran a follow-up. They ran the same ran the same query. What happened? His name came up, same set of facts, and now in addition to the non-existent Washington Post story, the actual op-ed that he wrote was now proof of a non-event. So the point is, we haven't figured out, so hallucinations happen, they happen, especially at the edge cases, between 3 and 25% of the time, according to people who have studied this. We have no way to fix this problem, and the bad data keeps coming and gets further in, as Jonathan Turley is sure to tell you. Anyhow, thank you. I'll take some questions.
You mentioned 3 areas. From personal experience, one of the biggest areas I see a big problem is in the biotech world. So when we have collaborations, sometimes there's foundational IP, and now everyone's using LLMs, right? And we're seeing a lot of battles happening between who owns the IP at the end of the day, who's creating it. If John's using an LLM, I'm using a different one, and we're coming up, where does that ownership happen? Are you looking into that area? Because it's becoming a big area of contention in terms of ownership of the foundational IP being built on it, and then the LLMs coming with their own stuff.
Right, yeah, the copyright offices have been dealing with this issue. They have said, basically, we're not going to give it, it goes back to the monkey selfie, really, which is the same idea. The monkey, about 8 or 9 years ago, a monkey walked up and took a selfie with a camera, and the owner of the camera applied for a copyright, and it was denied on the grounds it needs a human actor. And the question is, with copyright, is this a human actor or not? Is this created by a human? The query itself is covered by copyright.
Oh, it is?
The query, not the result, not the answer, not the whatever. It's not clear at all that you're going to get copyright in the result that comes out. And it's still an open subject, but I would guess not, because the monkey self and others sort of indicate there's no human really involved in producing the answer.
Okay, so another thing related to that.
That's a guess, by the way. It's not,
Yeah, so for example, Moderna has enterprise platform with ChatGPT, where they have a Chinese wall in terms of their IP and whatever research they do down there. Now, let's say they're using that LLM model out there, and then there's someone like, whoever, using another LLM, but they come up with almost the same thing. Where does that ownership happen? I mean,
well, we do have that in patent law, right? We have 2 different chains of inquiry or discovery going at the same time. There's a race to the patent office. There's also the thing, but we have that. If it's your data and you want to, the way to answer it is to keep it, in a sandbox or behind an air wall or something that keeps that data out from the public. But when you apply for a patent, you have to make all that public. That's the trade-off. You get 17 years, but you have to tell us what you did, or how you did it, depending on. Anyhow.
Sir, go ahead. Give you the microphone there.
Absolutely, I think everyone would agree that hallucinations are 2 to 25%. As we think about deploying AI, I think about 2 cases within the liability realm. The first is hallucination. So, an honest agent says something that's just wrong, right? And that has implications. That's number one. Number two is a user who has bad intentions, who wants the agent to say something wrong, jailbreaks the agent to say something wrong. Can you comment on a company's liability in both those cases?
So, you know, I mean, the law takes a long time, right? So, you know, chat, if you say chat is the leading LLM or the most prominent LLM, it's only been out for 2.5 years. That claim, which would be, you know, Turley's claim would be liable or something along those lines, has to get litigated, has to get appealed, then it goes, you know, it takes a while for that to happen. The question also is going to be, and it's a little bit like the driverless car. I'm going to move to another subject I know, which is it the car or is it the, you know, the driver? Especially when you don't have level 5. Level 5, just by the way, is like total. The car drives itself. If you have below that, you're supposed to be at least keeping an eye on the wheel. You know, with these. A lot of the recent crashes, you know, the driver is in there and is supposed to be maintaining it. So is it the car's fault or is it the driver's fault? It's sort of the same type of thing. Is the query giving rise to the wrong answer or whatever? Your second question was about if you jailbreak it. That's another level that hasn't really happened yet, I don't think. Although, you know, again, going back to the Turley thing, if there's bad information in the database that we're looking at, it's going to keep coming out and it's going to get replicated because the next query that talks about that is going to replicate them again, and there's going to write another op-ed, and then that's going to, you know, it's sort of like a race to the bottom here, or a potential race to the bottom. You can fix individual problems, which I'm sure OpenAI has done with regard to him, but the hallucinations you don't know about, the unknown unknown, if you will, or the unknown known, I don't know, whichever one it is, that's the danger, that you don't see the problem, and it's still there. So there's a theory that, there's two big theories, right? Well, there's three big theories. One is, let it go and the market will solve it, okay? There's another theory, which is we should have strict liability, and this is former Congressman Will Hurd, who's a CIA guy and ran briefly for president. He says strict liability. If you put it out there, you own it. And then there's a third major thing, which is licensing. So some sort of governmental agency, like we do with nuclear facilities, license them before you can put it out into the thing. I don't know if that horse may have left the barn already, but strict liability is also probably fighting uphill at this point.
Last question, go ahead.
Hi, my name is Han Ho. I'm a physician faculty at Harvard Medical School. So I also do expert witnessing as part of my practice. So I'm curious what you think or what you expect AI is going to help, I guess, for forensic collaborators of attorneys to do a better job. In the near
from an attorney or from a medical?
For the forensic collaborators of attorneys. Okay. So not the attorneys themselves, but the forensic.
So, I mean, the biggest use, or one of the biggest use cases in medicine is to sort of keep up on, you know, there's all these journal articles that come out and this is actually a very good use of, you know, for practitioners, is to summarize an article rather than me read, you know, 10,000 word articles, summarize each one, give me 500 words, and then I read the one that is relevant to what I'm doing. So I think from a you know, how do I get prepared for my expert witness, which is what you sound like you're asking. I would have, you know, whatever the latest articles are or journal pieces are that in my field or the field I got to prepare for, I'd have them summarized, and then I would look at the one, you know, read each summary, and then I'd go dig in on the one that seems most relevant to what you're talking about or what you expect your questions to come on. So I don't know if I totally answered the question, but that's sort of what I would say is the immediate best use case going, you know, for the foreseeable future.
Great, thank you very much.
Thanks.
Thanks.